we will now proceed with the lesson on preliminary investigation. So when we say preliminary investigation, it is required to be conducted before the filing of a complaint or information of an offense, where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. When we say preliminary investigation, it's an inquiry for us to assess if an offender really had committed a crime. And in general, what are the purposes of preliminary investigation? Well, it's to inquire concerning the commission of crime and the connection of the accused with it, in order that he may be informed of the nature and character of the crime charged against him, and if there is probable cause for believing him guilty, that the state may take necessary steps to bring him to trial. So this preliminary investigation, it actually aims to inquire into the commission of a crime and establish the connection of the accused to it. So this serves the purpose of informing the accused about the nature and character of the crime charged against them, and it provides an opportunity for the accused to understand the allegations and prepares them for the legal proceedings ahead. Second one is to preserve the evidence and keeps the witness within the control of the state. So, another purpose of this preliminary investigation, it's to collect and document evidence that may be crucial during the trial. Additionally, it helps in keeping witnesses within the control of the state, ensuring their availability to testify during the trial, and also to determine the amount of bail if the offense is bailable. So in cases where the offense is bailable, the preliminary investigation is utilized to determine the amount of bail. And we all know that this bail, it's a form of security required by the court to release the accused from custody while ensuring their appearance at subsequent court proceedings. And what are the principal purpose of preliminary investigations? It's to determine whether a crime has been committed and whether there is probable cause to believe that the accused is guilty thereof. It involves a careful examination of the available evidence to establish the existence of criminal conduct. Second, it's to secure the innocent against hasty, malicious, and oppressive prosecution. So we all know that the essential objective also of preliminary investigation is to safeguard innocent individuals from this oppressive prosecution. So it basically ensures legal actions are based on sufficient evidence and valid grounds, preventing unjust legal proceedings against individuals who are not guilty of the alleged crime. Next one, it's to protect him from an open and public accusation of a crime, from trouble, expense, anxiety of a public trial. So this preliminary investigation, it provides a protective mechanism for the accused by shielding them from an open and public accusation of crime. So this protection is vital to spare the accused from the trouble, the anxiety associated with public trial, and it allows for a more discreet and thorough examination of the case before it becomes a matter of public, and also to protect the state from useless and expensive trial. So by conducting preliminary investigation, the legal system aims to filter cases, ensuring that only those with a reasonable likelihood of success proceed to a full trial. So this helps allocate judicial resources efficiently, and avoids unnecessary burdens on the legal system. And when can there be preliminary investigation? It is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. Instances when is preliminary investigation required? Before a complaint or information is filed, preliminary investigation is required for offenses punishable by imprisonment of at least 4 years, 2 months, and 1 day, regardless of fine, except if the accused was arrested by virtue of a lawful arrest without a warrant. In case of lawful arrest without a warrant, the complaint or information may be filed without preliminary investigation unless the accused Next is whether or not there is a need for PI depends upon the imposable penalty for the crime charged in the complaint filed with the city or provincial prosecutor's office, and not upon the imposable penalty for the crime found to have been committed by the respondent after a preliminary investigation. Next, is there an instance when preliminary investigation is not required, even if the crime is one that requires PI? Yes, when the offender was arrested without a warrant. So this refers to warrantless arrest. Hot pursuit, if the offender is an escapee, and if it is in flagrante delicto. Is preliminary investigation a constitutional right? No. Preliminary investigation is not a constitutional right. It is merely a statutory right. Can preliminary investigation be waived? Yes, either expressly or by implication. When the accused failed to invoke his or her right to preliminary investigation before or after the arraignment, he or she is deemed to have waived his or her right to preliminary investigation. Is preliminary investigation a judicial proceeding? Yes, it is a judicial proceeding where the prosecutor or investigating officer acts as a quasi-judicial officer. Parties are given the opportunity to be heard and to produce evidence which shall be weighed and upon which a decision shall be rendered. Since it is a judicial proceeding, is also required in preliminary investigation. We have right here criminal investigation and preliminary investigation. Well, when we say criminal investigation, it's a fact-finding investigation carried out by law enforcement officer, whereas when we say preliminary investigation, it is conducted by the prosecutor. Mainly their difference is that who carried out this specific type of investigations. What is the probable cause for preliminary investigation? Because when we say probable cause, these are facts and circumstances as would excite the belief in a reasonable mind, acting on the facts within the knowledge of a prosecutor, that the person charged was guilty of a crime for which he was prosecuted. So, probable cause, it's a crucial standard in criminal proceedings, serving as the basis for initiating legal actions such as arrest, searches, and the filing of charges. And these are the procedure in conducting a preliminary investigation. So the complaint shall state the address of a respondent and shall be accompanied by the affidavits of the complainants and his witnesses, as well as other supporting documents to establish probable cause. And the affidavits must be subscribed and sworn before the prosecutor or the government official is authorized to administer such notary public. And also, within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. Next, within 10 days from the receipt of the subpoena with the complaint and the supporting affidavits and documents, the respondent shall submit his counter-affidavit and that of his witnesses and other supporting documents relied upon for his defense. The counter-affidavits shall be subscribed and sworn to and certified. The respondent shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. So upon receiving a subpoena along with formal complaint and supporting affidavits, a respondent is mandated to submit their counter affidavit. This is basically their reply, along with those of their witnesses and any supporting documents within a strict 10-day time frame. So this period is very crucial for the respondent to present a comprehensive defense against the allegations. So it is imperative that the counter affidavits are not only submitted within the stipulated time, but are also subscribed, sworn to, and properly certified. And if a respondent cannot be subpoenaed, or if subpoenaed does not submit counter affidavits within the 10-day period, the investigating office shall resolve the complaint based on the evidence presented by the complainant. So in a scenario where a complaint lodges a formal complaint against a respondent and the investigating office issues a subpoena requiring the respondent to submit counter affidavits within 10 days, the situation unfolds with the respondent failing to comply with the stipulated period. So in such case, the investigating office proceeds to resolve the complaint based on the evidence presented by the complaint. So the absence of counter affidavits from the respondent prompts the investigating authority to evaluate the available evidence, including documents and statements provided by the complainant. And the investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. The hearing shall be held within 10 days from the submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. Within 10 days after investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. Within the critical time frame of 10 days following the conclusion of the investigation, the investigating officer undertakes the crucial task of assessing the gathered evidence to ascertain whether sufficient grounds exist to warrant holding the respondent for trial. So what is resolution? Well, this, under the purview of the prosecution, it refers to the document prepared by the prosecutor that contains the result of his or her findings. That is whether holding the respondent for trial or dismissing the case or complaint. So it encapsulates the prosecutor's findings and serve as a pivotal decision point regarding the fate of the case or complaint. And resolution of investigating prosecutor and its review. Well, if the investigating prosecutor finds a cause to hold respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he, or as shown by the record, an authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed, and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor, or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. They shall act on the resolution within 10 days from the receipt thereof, and shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by investigating officer, investigating prosecutor without a prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. Where the investigating officer prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor, or chief state prosecutor, or the ombudsman or his deputy on the ground that a probable cause exists, the latter may, by himself, file the information against the respondent, or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party under such rules as the DOJ may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to file the corresponding information without conducting another PI, or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rules shall apply in PI conducted by officers of the Office of the Ombudsman. So, inquest, investigation, or inquest proceeding. So, it is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant issued by the court. This process is particularly relevant in situations where immediate action is required, such as when individuals are arrested without a warrant. So, what is the purpose of inquest? The purpose of inquest proceeding is that while the state acknowledges the law enforcer's authority to arrest and detain the persons without a warrant, the state must also ensure that persons are not unlawfully detained and that they are not denied due process. The inquest establishes whether the evidence is sufficient enough to seek court approval to keep the person in detention. So it served the purpose of balancing law enforcement authority to arrest and detain individuals without a warrant with the need to prevent unlawful detention and uphold due process. When individuals are arrested without a warrant, the state conducts an inquest to determine if there is enough evidence to justify their continued detention. Commencement and termination of inquest. Well, the inquest proceedings shall be considered upon receipt by the inquest officer from the law enforcement authorities of the complaint referral documents, which should include the affidavit of arrest, the investigation report, the statement of the complaint and witnesses, and other supporting evidence gathered by the police in the course of a latter's investigation of a criminal incident involving the arrested or detained person. The investigating officer shall, as far practicable, cause the affidavit of arrest and statements, affidavits of the complainant, and the witnesses to be subscribed and sworn to before him by the arresting officer and the affiants. The inquest proceedings must be terminated within the period prescribed under the provisions of Article 125 of the RPC as amended. The inquest requires the prosecutor to resolve the complaint that the police filed in a prescribed period, which varies depending on the gravity of the offense. Cases punishable for light penalties, it should be 12, correctional 18, afflictive 36. So this is stated on the Article 125 of the RPC. Hence, if the inquest prosecutor fails to complete the proceedings in the prescribed period, then the person must be released. In case documents are incomplete, when the documents presented are not complete to establish probable cause, the investigation officer shall direct the law enforcement agency to submit the required evidence within the period prescribed under the provisions of Article 125 of the RPC as amended. Otherwise, the IO shall order the release of a detained person, and where the inquest is conducted outside of office hours, direct the law enforcement agency concerned to file the case with the city or provincial prosecutor for appropriate action. Initial duty of the inquest officer. Well, the inquest officer must first determine if the arrest of a detained person was made in accordance with the provisions of rules and criminal procedure as amended, which provide that arrest without a warrant may be effected when, in the presence of arresting officer, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. So this refers to in flagrante delicto. Next is when an offense has in fact just been committed and the arresting officer has personal knowledge of facts indicating that the person to be arrested has committed it. For this purpose, the inquest officer may summarily examine the arresting officers on the circumstances surrounding the arrest or apprehension of a detained person. So letter B, this refers to the hot pursuit rule. So where arrest not properly effected, should the inquest officer find the arrest was not made in accordance with the rules, shall, of course, here's what would happen: recommend the release of a person arrested or detained, note down the disposition of the referral document, prepare a brief memorandum indicating the reasons for the action taken, and forward the same together with the record of the case to the city or provincial prosecutor for appropriate action. Next is where the recommendation for the release of a detained person is approved by the city or provincial prosecutor, but the evidence on hand warrant the conduct of a regular preliminary investigation. The order of release shall be served on the officer having custody of said detainee, and shall direct the said officer to serve upon the detained the subpoena or notice of preliminary investigation together with the copies of the charge sheet or complaint, affidavits or sworn statements of the complainant and his witnesses, and other supporting evidence. So where arrest properly effected, should the inquest officer find the arrest was properly effected, the detained person should be asked if he desires to avail himself of a PI, and if he does, he shall be made to execute a waiver of the provisions of Article 125 of the RPC as amended with the assistance of a lawyer, and in case of non-availability of a lawyer, a responsible person of his choice. The preliminary investigation may be conducted by the inquest officer himself or by any other assistant prosecutor to whom the case may be assigned by the city or provincial prosecutor, which investigation shall be terminated within 15 days from its inception. When probable cause is present. So here's what would happen. If probable cause exists, he shall forthwith prepare the corresponding complaint information with a recommendation that the same be filed in court. The complaint information shall indicate the offense committed, the amount of bail recommended, if it is bailable, of course. Thereafter, the record of the case together with the prepared complaint information shall be forwarded to the city or provincial prosecutor for appropriate action. And the complaint information may be filed by the inquest officer himself or by any other assistant prosecutor to whom the case may be assigned by the city or provincial prosecutor. And when probable cause is absent, so what would happen? If there is no probable cause, of course, he shall recommend the release of the arrested or detained person. I think we've discussed this already. Yeah. What's the relationship of the police with the prosecutor? So paramount to the prosecutor's role is to establish at the initial stages that a probable cause exists that a crime has been committed. So this requires close coordination with investigating agencies like the PNP, NBI, and quasi-judicial bodies empowered to conduct investigation. Hence, there shall be coordination between the prosecutors and the police in principle to ensure that evidence collected stands up to judicial scrutiny even at the early stages of a case. So, courts rely heavily on the evidence submitted by the prosecution panel, which comprises the work of both the police and prosecutor. And when probable cause is absent, should the city or provincial prosecutor disapprove the recommendation of the release of the arrested or detained person, shall remain under custody, and the corresponding complaint or information shall be filed by the city or provincial prosecutor or by any assistant prosecutor to whom the case may be assigned. Is preliminary investigation a matter of right? It is a matter of right only when the crime committed is punishable by penalty of at least 4 years, 2 months, and 1 day, regardless of the amount of fine. What is the effect if PI is not accorded to the respondent or the accused? There would be a violation of due process. Who are the persons authorized to conduct PI? It's provincial or city prosecutors and their assistants, the national and regional state prosecutors, and other officers as may be authorized by law. So we have here an example of other officers authorized by law to conduct PI. The ombudsman and special prosecutor and public prosecutors duly authorized by the ombudsman with respect to cases under its jurisdiction. The COMELEC with respect to cases in violation of election law. Private lawyers when duly deputized by any of the above. And we have another question here. Are all judges authorized to conduct PI? The answer to this, no, not anymore. The reason is that due to conflict of interest. We have here, is the mayor authorized to conduct PI? The answer is no, not anymore. So solely the authorization when it comes to conducting PI, it's the job of the prosecutor. Here are the effects and nature of a PI. Well, it is merely inquisitorial, meaning it is an inquiry or investigation initiated by the prosecuting authority to gather information and determine the merits of a case. Second one, it is the only means of discovering whether the offense has been committed and the person responsible for it. So this preliminary investigation, it means to discover whether an offense has been committed and to identify the individuals responsible for it. And third one, it enables the fiscal to prepare his complaint and information. So the PI allows the fiscal. Fiscal is the old term for prosecutor. So it allows the fiscal to prepare formal complaint and information that will be presented in court. So it involves careful review of evidence and statements gathered during the investigation. Fourth one, it is not a trial on the merits. So it is essential to note that PI is not a trial. Instead, it focuses on determining whether there is sufficient basis to proceed with a formal trial. Fifth one, it determines whether there is a probable cause to believe that an offense has been committed and the accused is probably guilty of it. So the primary objective of PI is to assess whether there is probable cause to believe that an offense has occurred and the accused is likely guilty of committing it. This determination guides the decision on whether formal charges should be filed. And it does not place the accused in jeopardy, meaning a PI does not subject the accused of jeopardy wherein it should not place them at risk of being prosecuted or punished. Seven, it does not affect the jurisdiction of the court. So it influences the regularity of the proceedings, and the court retains its authority but considers the findings of the investigation. The accused cannot assert lack of preliminary investigation. Court cannot dismiss the case based on this ground. It should conduct the investigation or order the fiscal or lower court to do it. So the accused cannot assert the lack of PI as grounds for dismissal. Instead, the court is obligated to conduct the investigation itself or instruct the prosecutor or a lower court to carry it out. And 9, PI may be waived. So in certain circumstances, the right to PI may be waived, indicating the accused's voluntary decision to proceed without this initial inquiry. 10th, the accused doesn't have full gamut of rights yet. He doesn't have right to counsel unless a confession is being obtained from him. So during PI, the accused does not have the full rights. For instance, the right to counsel may not be automatically granted unless a confession is being obtained from the accused, indicating a more limited scope of rights at this stage. And another effects and nature of PI, so 11 would be, the accused should invoke right to PI before the plea, otherwise it is deemed waived. So the accused is required to invoke the right to a PI before entering a plea. Failure to do so is deemed as a waiver, indicating that the accused voluntarily relinquished the right to this initial inquiry. 12 is, there is also no right to confront witness against him. So during PI, the accused does not have the right to confront witnesses against them, unlike a formal trial where the right to confront witnesses is recognized. The right is limited or absent during the PI stage. What is the effect of the PI or preliminary investigation overall in the administration of criminal justice system? Well, it's to reduce the backlog and congestion of cases in our courts. Next is prosecutor's discretion. So the role of prosecution involves critical decision-making process in determining the course of legal proceeding. So the prosecution is responsible for, first one, whether or not to file the case in court. So the prosecution decides whether there is sufficient evidence and legal basis to file a case in court. This involves a thorough review of the evidence gathered during the investigation to ensure it meets the standards required for formal legal proceedings. Next, what charges to file. So based on the evidence and the nature of the offense, the prosecution determines the charges to be filed against the accused. And the third one, whether or not to decline to prosecute the arrested party. That's also one of the discretion of the prosecution. So it's up to the prosecution to decide whether or not to pursue the prosecution of arrested party, and whether or not to enter into plea bargaining. So the prosecution also involves into discussions between on the defense to reach a mutually accepted agreement on stages, on charges, sentencing, or other aspects of a case, often in exchange for the accused's cooperation or admission of guilt. And reasons for prosecutorial rejection or dismissal of some criminal cases. So we have here, one primary reason is the insufficient evidence that results from a failure to find sufficient physical evidence that links the defendant to the offense. So if the prosecution fails to find physical evidence or establish a connection between the defendant and the alleged offense, it may lead to the rejection or dismissal of a case. Next is, a case may be dismissed if it has witness problem. So problems with witnesses such as their credibility, reliability, or availability can impact the prosecution's ability to build a strong case. And if witnesses are unwilling to testify, or if their statements are inconsistent or unreliable, it may result in the rejection or dismissal of a case. Third one is due process problem. So violation of the defendant's due process rights or procedural irregularities in investigation or legal proceedings can lead to the rejection or dismissal of a case. And this may include issues related to the collection of evidence, handling of a defendant's rights. May determine that based, the prosecution may determine that based on the evidence. And Factors that may influence prosecutorial decision. Well, the pressure from the public and the media. So prosecutors may feel pressure from public opinion and media coverage, which can influence their decisions. So public perception and media attention can impact the perceived importance of a case. Next one is the desire to get rid of a suspect who is particular problem to the community. So the desire to address a suspect who possesses or who poses a particular problem to the community may also influence prosecutorial decision, because considerations for community safety and well-being may shape the decision-making process. Next is the belief that new evidence would be discovered and that such evidence would be favorable to the suspect. So here, ongoing investigations or the possibility of exonerating information may be factors that can influence the prosecutor's decision. Next is the nature of the complaint and the attitude of the offended party. So here, the victim cooperation is often crucial for a successful prosecution. And the nature of the complaint and the attitude of the offended party, including their willingness to cooperate or testify, can play a role in prosecutorial decision. Next is the seriousness of the offense. The severity of the alleged offense is a significant factor. Prosecutors may allocate resources based on the seriousness of the charges and the potential impact on the community. Next is the exchange of the relationship among the components of the CJS, as well as the congestion within and the resource demands placed upon the system. And thus, does the prosecutor have a greater discretion than the police? Yes, the prosecutor has even a greater discretion than the police, because the prosecutor can dismiss a case. Can dismiss, or they can file a case to the court. Is it possible to interfere or to control prosecutorial decision? No, that's the general rule. For the reason that there is doctrine of separation of powers. So, the law enforcement cannot interfere with the prosecutorial decision. The court cannot also control that, as well as the correction and the community. And what are the remedies available should the prosecutor, without just cause, decline to prosecute the crime? So, here are some remedies that you can do. You can file a motion for reconsideration. So the affected party can formally request the prosecutor to reconsider their decision, and that involves submitting additional evidence or arguments to persuade the prosecutor to review the case again. Next, file an admin appeal with the Secretary of Justice. So if the prosecutor's decision is still unsatisfactory, the affected party may appeal to a higher authority. Next is file an admin case against the prosecutor. So in case of alleged misconduct or violation of ethical standards, the affected party may file an admin case against the prosecutor. Then they may also file a civil case against the prosecutor. So if the prosecutor's decision results in harmful or damages to the affected party, they may consider filing a civil case. And this legal action seeks compensation for any losses incurred during the prosecutor's alleged negligence or wrongful conduct. Also, they may file a special civil action for grave abuse of discretion. So this remedy is applicable when the prosecutor's decision is deemed to be arbitrary or is issued with grave abuse of discretion. Next is you can also file a criminal case against the prosecutor. So in exceptional cases where the prosecutor's action amount to criminal offense, such as corruption or willful violation of a law, the affected party may file a criminal case against the prosecutor. So that's the end of the discussion. And if you have questions, just feel free to ask me.